Now we are going to see about some certain problems which is in the question paper of the previous years. The first problem is about advertisement and prospectus and its validity. A company issued an advertisement in a newspaper stating that some shares were still available for sale according to the terms of the prospectus, which could be considered as a prospectus or not. Is an advertisement itself a prospectus or not? It was said that for every new allocation or every new subscription allotment, there should be a prospectus, right? So once a prospectus is done already, there were some shares which is remaining and the ad was placed. In that scenario, whether the ad itself a prospectus or not. For that, we need to refer section 25 to section 30 of Companies Act and the prospectus definition. The definition of prospectus is set under section 2 of subsection 70 of the Companies Act. A document that offers securities for subscription to the public is called as prospectus. And a content of prospectus are objects, liability, the capital structure of the company, the names of the directors, details of the company, previous year profit and loss, everything to be there in the prospectus to keep the upcoming members, shareholders, or the stakeholders informed about the status of the company. An advertisement itself is not automatically become a prospectus unless it satisfies all the full statutory requirements of a prospectus. A newspaper ad is not a valid prospectus over here. All these contents, if it is there in the public paper, still it is to be submitted to register of companies before the subscription. So in that scenario also, even an advertisement has all these contents, it might not be submitted to a register of companies as it is circulated first than the submission. Hence an advertisement itself is not a prospectus. That we can decide out of this. And the second problem is about pre-incorporation. A. The promoter, on instructions of a certain gentleman, prepared the necessary documents and obtained registration of a company. He paid registration fees and incidental expenses. Afterwards, the company refused to pay A. How and why? Whether A can obtain the amount what he has spent or not. So this is the question over here. A promoter's duty is to do all the work and bring a company for its incorporation. Here A, the promoter, has incurred costs before the incorporation to get the company registered, which means a company itself is not existent. Before the birth of the company, how the company could enter into a contract? So there is no contract between the company and the promoter. If there is no contract between the company and the promoter, how company will pay? How company will have the liability to pay? There is no need, right? So a company need not to pay unless there is pre-incorporation contract between the promoter and the company. If there is a pre-incorporation contract, or else if there is any post incorporation contract to adopt promoters as its members itself. In that scenario, A, the promoter can get the money back, else it's not automatically reimbursed for him for an reincorporation, and there is no base for this question itself to ask the money from the company. Even though he spent for the company, he can't automatically get reimbursed, or he can't get the money back unless there is no adaptation. There is a concept called novation, where a promoters were substituted by the company, and all the contracts made by the promoters is substituted by the company, and company will be liable. So that is post incorporation contract. If there is no such novation, so the possibility of getting money is not there. There is a case law where we can see Kellner and Baxter. In this case, promoter personally liable for the things ordered for an unformed company, and promoters are made personally liable, not the company. So promoters and the company itself different, and expenses obtained by the promoters is not necessarily to be paid by the company. And the next question is about alteration of registered office of a company. According to the Companies Act, Section 12, every company which is registered in India in this act should have a registered office in India. Every company comes under this act only comes when there is an office in India, a registered office in India. Both ways. So, registered office is so important that because all the jurisdiction will come in this base, all the company transaction, register of companies, everything is based on this registered office, which was registered during MOA promotion, that period itself, in the MOA itself, during the creation and incorporation of the company. So the location of the company is that much mandatory. We can change the location within the same district, that's not an issue. Within the same jurisdiction, we need to just give a notice to the register of companies that we are changing the location. If we are changing inside the state also, there will be a more or less same jurisdiction, just a slight differences based on zones. It's easier, so that is just an administrative task. You need to get the board resolution and give a notice to register of companies. If there is a four board members or 14 board members, just they want to discuss, get it approved, they can go ahead with the change of location. If there is a change of state itself, the process might change, whole jurisdiction will change, whole control will change. In that scenario, a special resolution made by the members, it's not board members, by the members, which is shareholders, including shareholders, there should be a special resolution and a permission by the central government, which is of course Department of Corporate Affairs, the Register of Companies. A special resolution by the members of the company and the government permission. If both are there, they can go for the new office. The company must pass a special resolution for the change of address, the change of state, then seek an approval, and then they can change the location from Maharashtra to Karnataka. They can shift from Maharashtra to Karnataka. And then the next question is about supremacy of law. What comes first? Whether an article of association can overrule through some articles which is there in the AOA. Articles of association stated that A, the person, shall be the director and shall not be removed until a certain year, 2015. He was removed earlier, before 2015. Now, A, the person, sues for damages to the company, whether he can succeed or not. Actually, it is not right to state a specific time to become a director because it overrides the articles of association. Articles of association overrides the act. Section 6 says about the Companies Act can override the provisions of articles of association, and act comes first before the validity of AOA. And section 169 state about removal of directors and their procedures to be followed. If those directors are removed as per the section 169, even though articles of association is having that he can't be removed, still that removal will be a valid one. There are two, three reasons because AOA cannot override the Companies Act, and the removal process are within the provisions of the act and it is taken procedurally, and the AOA's that clause itself is not valid. It is a ultra virus because it conflicts with law, so he cannot proceed for the claim of damages. And the next problem is about quorum. A quorum is a minimum number of members to be present in a meeting to make the meeting a valid one. If there is a quorum is present, the meeting will be valid. We can directly go to the answer. So there are two aspects. Ethically right and legally right are totally two different things. Even though members were prohibited from attending the meeting by some dominant directors or dominant members, it's ethically wrong and the meeting will be a legally valid meeting. Ethically, it's invalid meeting because they didn't give an equal opportunity. It was done behind the scene, but legally the meeting is still valid unless and until quorum is present. There are scenarios that there are provisions for the dominance to avoid dominance of the big shareholders to the minority shareholders who have a less than 5 percentage of shares in the company. So in that scenario there are certain circumstances that we can sue the dominant shareholders against their activity, but the action should be in a series of uh, actions. It's not a one single action but a series of action to prove that they have an ill illicit thoughts behind their actions. Unless it is not proved and it's not a series of actions, we can't sue them or we can't say that we are prohibited from being there. So it is not going to be, until and unless it's not going to be proven, the meeting is still going to be a valid meeting. So if there is any other questions, we can have a part 2, and please put it in the chat if there is any other provisions or case laws which you can connect with, so other members who can see will extend their knowledge and we can see in our next revision.